Welcome to the video everyone, and I'm going to be talking about the importance of case law, especially in the UK system of law and justice. And in my last video I talked about the Hill immunity which the police have right now, and that's to do with a court case which was brought against them at the time of the Jack the Ripper, and one of the victims' mothers brought a claim against the police. In the judgment it said that the police did not owe a duty of care to individuals. However, this started to get turned over with Robinson, which is a court case which I will be bringing, a case law which I will be using in my own claim. However, Robinson is a little bit different because it's a positive rather than a negative. So an act or an omission which is negative, then you cannot bring the claim against them, and I'll have to sort of go through understanding what the positive and the negative actually means. But this was allowed to happen. This case law was brought and allowed for a negligence claim against the police based upon the free stage of Caparo. So we'll have a look at Caparo. And it's a legal framework used in English law to determine if a duty of care exists in negligence claims. And it's a really interesting aspect of the law and justice. So there's foreseeability. The harm of a claimant must have been reasonably foreseeable as a result of the defendant's actions or inactions. Well, if you consider that the judgment in Hill versus the police chief constable, the immunity, the judgment in that stated that they would not allow negligence claims against the police because that would bring about defensive policing. And so the police have applied defensive policing anyway through DEI training, which is diversity, equality and inclusion. So they've brought about that when the judiciary have warned them that they must never go into defensive policing. So I'm going to do a bit of sucking up to the judiciary in my court case, saying that they were warned not to do this by the judiciary, that it was foreseeable because the judiciary had recognised the issue with defensive policing. So I have got foreseeability and I have got evidence of the harms recognised by others, the reasonable person test. There's a reasonable person test. Would it happen to a reasonable person? We'll just we'll have a look at the negligence requirements in a minute. Proximity. There must be sufficient proximity or a close relationship between the defendant and the claimant for a duty of care to arise. Well, they are the police, and we are supposed to be able to go to them if any crimes have committed. I've got further evidence that a further crime was committed against me, and that I will not be going to the police because they are activist police. They are not, they're political police. They're not police. They, as far as I'm concerned, if they're going to be activists, then they are unapproachable to people who may not or do disagree with the with their politics. So now that they've become activist police and defensive police, they are unreliable and unapproachable, and that's another proximity that I'm going to be using. Fair, just and reasonable, number 3. It must be fair, just and reasonable to impose a duty of care on the defendant in the specific circumstances. So this isn't a whole opening to everyone can just dive in, but it's specific to each case. And I think that it will be. fair, just and reasonable. I hope I can change these laws. I've always said that for me, the most important part of what I'm doing is judgment. I absolutely want judgment. So here are the 5 other elements of negligence claim which we've got to, which I have got, or 4, sorry. I think it's 5 in America. In the UK it's 4. Duty of care. This means the defendant owed a legal obligation to the claimant to take reasonable care to avoid causing them harm. This duty can arise from various situations, like a driver's duty to other road users and a professional's duty to the client. And then there's the police. They have a duty of care to be approachable, and it's even in Peel number 5 of the Peel principles, which states that they must not hold a bias. So when they're doing DEI training, that is a bias, and that is ideology. It's political correctness, which is ideology. Breach of duty. The claimant must prove the defendant failed to act as a reasonable person would have in the same circumstances. And this is what I'm talking about with the proximity, foreseeability in Caparo. The harm to the claimant must have been reasonably foreseeable as a result of the defendant's actions or inactions, and it was foreseeable. That's why they received Hill immunity, to prevent the defensive policing. So I've cracked that one, and here we go again. The claimant must prove the defendant failed to act as a reasonable person would have in the same circumstances. So that applies to the Caparo test. This could involve an action or inaction. So an action is a negative and an inaction is a positive. I think that's how we're seeing it with the police immunity. But falls below the expected standard of care. Number 3, the causation. This might be tricky, but I don't think so. I think I've got this. The claimant must demonstrate a direct link between the defendant's breach and the harm they suffered. This is often broken down into 2 parts: factual causation, and that's the but-for test. But for the defendant's breach, would the claimant have suffered the loss? And the legal causation, which is whether the damage is too remote. I'm arguing that as soon as they put in DEI training, which came about in 1999 with the Macpherson report. Now, the Macpherson report applied that aspect broadly to all of public sector. And you've really started to see it come into the NHS in 2020. And I'm going to be suing the NHS for DEI as well. It really started to bring itself into the DEI, into the whole entire public sector. But it can't be applied properly to all of the above, because then it will apply discrimination, which you're not allowed to do. They may say it's too remote because it came in 1999, but the first instances of grooming gangs were made public in 2004. So there's a link between the DEI training and causation, which has been going on for 25 years, 26 really. Damages. The claimant must have suffered some form of loss of injury or as a result of the defendant's breach. Well, I have done, and I've got this can include physical injury, property damage, and financial loss, or even psychological harm. So I can apply for financial loss and property damage, all of it basically, because I'm bringing a claim against them for losses which I've received long term from 2012, but also more recently when another crime came about against me. I'm going to be claiming that back from the police, not just one police force. I'm going to be bringing it against every police force here. Say hello to one of my defendants. National Policing, this is a College for Police or College of Policing. I'm going to be suing them as well. They're going to be defendants. We're doing the Culture and Inclusion Strategy 2025 to 2030. They've plonked it right on their website, and I'm bringing legal action against them. Cultural change, they're going to be changing all of the culture of the police even further. Changing the culture of police is vital to meet our ambition of a truly inclusive organisation. We need to improve trust, confidence and legitimacy from the communities we serve. Well, by doing what they're doing, I'm not reporting crimes, so they're failing. This is not a nice to have. It is at the heart of good policing and impacts on our ability to deliver improved outcomes for the public in preventing and responding to crime. So here's the 9 Peel principles. To prevent crime and disorder as an alternative to their repression by military force and severity of legal punishment. Well, that's what's happening now. They're bringing about loads of legal cases because the Macpherson report in 1999, it recommended that they apply non-crime crimes against people. And what they do to apply that is use the Public Order Act 1986, which is about speech and stirring up racial hatred. Well, I've proven that they've breached that law themselves. I'm using the law that they used to oppress us against them. To recognise always that the power of the police to fulfil their function and duties is dependent on public approval of their existence, actions and behaviour, and on their ability to secure and maintain public respect. Well, if they've become activist police, you can't continue in that aspect because you've become biased, and those people who don't necessarily agree with your biases are not going to use you. That's what number 5 is all about: to seek and preserve public favour, not by pandering to public opinion, and that would include media opinion, but by constantly demonstrating absolute impartial service to law, in complete independence of policy, and without regard to justice or injustice. Oh, bloody hell, it's a really long sentence, this. But basically it's saying don't hold biases, but be friendly to the public. And it was 1829. So it's worked for over 100 years, then suddenly they start manipulating the whole policing principles to become DEI, and it's just become useless and rubbish. I've got another page here that's saying that the public trust and confidence in police has declined rapidly. In October 2024, 52% of the adults told YouGov survey of Great Britain that they had no or not very much confidence in the police to tackle crime locally, compared to 39% in 2019. Well, 2019 was when there was all this crackdown and oppressive behaviour by the police surrounding lockdown. Over the last 25 years, there have been long-term reductions in the level of recorded crime, alongside increases in the number of police officers. There's a problem with this sentence. To have recorded crime, you've got to have it reported. And if people like myself are victims of crime, but we're not willing to report it to the police because they're oppressive and they're biased, because if you remember, it took 3 years for me to report a rape to them because it was a politically correct rape. I mean, how can you go to a politically correct police force about a politically correct rape? You can't. It takes a lot of confidence, and you know, I didn't have confidence in them, and they have since lost some evidence as well. So I desperately want to get negligence, because the thing is, case law is so much more important than the legislation in this country, and probably in America and in various common law countries. Somerset and Stewart, I've talked about this before, and this was about a Jamaican who was forcibly removed from Jamaica for sale. And according to one reported version of the case, Lord Mansfield decided that, and this is a great judgment. I think it's really telling about the time that we are in. The state of slavery is of such a nature that it is incapable of being introduced on any reasons, moral or political, but only by positive law, which preserves its force long after the reasons, occasions, and time itself from whence it was created is erased from memory. He's saying that positive law, which is actually statute law, legislation that we have now, is very oppressive, and he disagrees with statute law. And that's the mindset that they had in 1772. And you think about when the police arrived, so he's criticising the statute law. Then 60 years later or something, we've got the police, who have now become an oppressive force against the people of the UK, and not just in the UK, but in every country. It is so odious. This is slavery. This is how Britain feels about slavery on the shores of Britain. We were not slave traders. People were out and about doing slave trading, but that wasn't the British people. And this is sort of being used against us, making claims that all Britons were selling slaves and stuff. And that's not the case here. It wasn't the case in America. It wasn't all Americans were doing that. It is so odious that nothing can be suffered to support it but positive law, statute law. Whatever inconveniences, therefore, may follow from the decision, I cannot say this case is allowed or approved by the law of England, which is common law, and therefore the black must be discharged. So the black Jamaican slave had to be removed from the slave owner and sent back. Now, what I'm concerned about Human Rights Act being removed by Nigel Farage, because what I'm expecting to happen is wars and then conscription. So I feel that what's going to happen in the future is they're going to start all these wars, like World War III, and they're going to conscript all of the British, white British probably, citizens into war, probably because it will pay well as well. I think a lot of people will be struggling financially, so they'll probably just do it for the money. But I think that that's going to happen, and the Human Rights Act will give people a way out of signing up, or conscientious resistors, so that they can argue in the courts that they do not want to go to war. So I feel that the Human Rights Act is really important to help with that. But I have found another legislation which I know will work, because I'm going to be using this legislation in my own case. And it's quite old. It's only been used once in the UK, and that was for a criminal case. I'm going to be using it for a civil case, and I'm going to be using it against the police. And it was around about February time when I realised that there was a possible case against the police. And when I realised that, I basically went all in. I gambled and went all in on this case. And I'm absolutely going to throw down that wall of immunity that the police have got. I'm absolutely determined, and I'm going for judgments. I just want judgments all the way. That's all I'm interested in. So I'm looking forward to these cases. Another example of case law which has had a profound effect on the UK is Donoghue versus Stevenson, and that brought about the neighbour principle, which is the duty of care principle, which negligence talks about. Duty of care is the neighbour principle, which is what Donoghue versus Stevenson. And her case, she was a peasant woman. She's my inspiration, because she was a peasant woman and she brought her own case against the manufacturers of a ginger beer drink or something like that, and she won. And then because she'd won, she argued as to how they owed her a duty of care for the neighbour principle. So it's really, these cases are so important. I would argue that case law is far more powerful than legislation. And this is why it's so important that I go to judgment on all of these cases. I'm absolutely passionate about it because I know I'm going to win. And you know what? When I brought my last case against the CICA, my rape case, I knew that I was going to win. I knew because I had so much strong evidence, and I did, and I set precedent because I'd argued that I did not go to the police for 6 months, for 3 years, because first of all I had brain surgery, so I had a bit of a memory problem. But then they were saying, well, you didn't go to the police after you'd recovered from that. You had sufficient time to recover. So I argued, well, I didn't go there and report the crime to the police because the police are activist police and I don't trust them. And I did in the end because I felt I owed a duty to other people to warn them about what the police were allowing and enabling. But I didn't do it because I trusted the police, not at all. And I won on that. I've won on DEI already, so I know that I can win on DEI with negligence. And honestly, there's just some force behind me, which I can only explain as being God. And he's just telling me to do this, and I am going to do it, and I am going to win. And I'm absolutely confident about that. And then the floodgates open against the police, and I can't wait. Because, yeah, they've already applied defensive policing. They're going to be screwed when I'm done with them. There is some little issues with my current cases not seeming to be going through the courts or being acknowledged by the courts, while other cases which I've been writing up and representing, they are getting granted. They've received the grant from the courts to say, yes, we'll allow that case to go through, but mine haven't so far, so I'm going to have to check up on that. But it could just be that they're sending the information to the wrong address or something, I don't know. So it could just be simple, hopefully. I'll leave it there. I'm having a bit of a rant, but I'm very excited about my court case. I'm going to be bringing negligence. I'm going to win, and I'm going to recover all my losses 8 times over, because that's how many forces I'm bringing it against. Although I am searching the internet for any other forces who I can bring against. I think I might do Yorkshire, West Yorkshire. I think I've got enough evidence on them too. So I'm going to be bringing lots of claims against them, and there will be disability discrimination, race discrimination and gender discrimination, as well as malfeasance, misfeasance, nonfeasance, torture, all sorts of things. It's going to be very exciting because I'm going to win. So I'll leave it there for now. This is just about the power of case law. It's such a powerful thing, and I definitely want to get judgments. That's all I'm interested in. Even if I lose, there's still judgments, and they'll still apply tests and different aspects of the law. They may even create new tests and things. So it's not, even if I lose, which I really don't think that I'm going to, but if I did, it would still have significant effect on the way that cases are used in the future, or sort of considered in the future. So this is a very exciting time for me, and I do believe that I'm going to win. So I'll leave it there. Please like, subscribe and leave a comment. Thank you very much. Bye.